Hello, everyone. Today we're going to wrap up Citizens United versus FEC. So right now we are in Justice Stevens' opinion, who's concurring in part and dissenting in part. Okay, so the final principle of judicial process that the majority violates is the most transparent, stare decisis. I am not an absolutist when it comes to stare decisis, in the campaign finance area or in any other. No one is. But if this principle is to do any meaningful work in supporting the rule of law, it must at least demand a significant justification beyond the preferences of 5 justices for overturning settled doctrine. A decision to overrule should rest on some special reason over and above the belief that a prior case was wrongly decided. No such justification exists in this case, and to the contrary, there are powerful prudential reasons to keep faith with our precedents. The court's central argument for why stare decisis ought to be trumped is that it does not like Austin. The opinion was not well reasoned, our colleagues assert, and it conflicts with First Amendment principles. This, of course, is the court's merits argument, many defects in which we will soon consider. I am perfectly willing to concede that if one of our precedents were dead wrong in its reasoning or irreconcilable with the rest of our doctrine, there would be a compelling basis for revisiting it. But neither is true of Austin. As I explained at length in parts 3 and 4, and restating a merits argument with additional vigor does not give it extra weight in the stare decisis calculus. Perhaps in recognition of this point, the court supplements its merits case with a smattering of assertions. The court proclaims that Austin is undermined by experience since its announcement. This is a curious claim to make in a case that lacks a developed record. The majority has no empirical evidence with which to substantiate the claim. We just have its ipse dixit that the real world has not been kind to Austin, nor does the majority bother to specify in what sense Austin has been undermined. Instead, it treats the reader to a string of non sequiturs. Our nation's speech dynamic is changing. Speakers have become adept at presenting citizens with sound bites, talking points, and scripted messages. Corporations do not have monolithic views. How any of these ruminations weaken the force of stare decisis escapes my comprehension. The majority also contends that the government's hesitation to rely on Austin's anti-distortion rationale diminishes the principle of adhering to that precedent. Why it diminishes the value of stare decisis is left unexplained. We have never thought it fit to overrule a precedent because a litigant has taken any particular tack, nor should we. Our decision can often be defended on multiple grounds, and a litigant may have strategic or case-specific reasons for emphasizing only a subset of them. Members of the public, moreover, often rely on our bottom-line holding far more than our precise legal arguments. Surely this is true for the legislatures that have been regulating corporate electioneering since Austin. The task of evaluating the continued viability of precedents falls to this court, not to the parties. Although the majority opinion spends several pages making these surprising arguments, it says almost nothing about the standard considerations we have used to determine stare decisis value, such as the antiquity of the precedent, the workability of its legal rule, and the reliance interests at stake. It is also conspicuously silent about McConnell, even though the McConnell court's decision to uphold BCRA subsection 203 relied not only on the anti-distortion logic of Austin, but also on the statute's historical pedigree and the need to preserve the integrity of federal campaigns. We have recognized that stare decisis has special force when legislatures or citizens have acted in reliance on a previous decision, for in this instance, overruling the decision would dislodge settled rights and expectations or require an extensive legislative process. Stare decisis protects not only personal rights involving property or contract, but also the ability of the elected branches to shape their laws in an effect of Today's decision takes away a power that we have long permitted to these branches to exercise. Let me back up. Stare decisis protects not only personal rights involving property or contract, but also the ability of the elected branches to shape their laws in an effective and coherent fashion. Today's decision takes away a power that we have long permitted these branches to exercise. State legislatures have relied on their authority to regulate corporate electioneering, confirmed in Austin, for more than a century. The federal Congress has relied on this authority for a comparable stretch of time, and it specifically relied on Austin throughout the years it spent developing and debating BCRA. The total record it compiled was 100,000 pages long, pulling out the rug beneath Congress after affirming the constitutionality of subsection 203 6 years ago shows great disrespect for a co-equal branch. By removing one of its central components, today's ruling makes a hash out of BCRA's delicate and interconnected regulatory scheme. Consider just one example of the distortions that will follow. Political parties are barred under BCRA from soliciting or spending soft money funds that are not subject to the statute's disclosure requirements or its source and amount limitations. Going forward, corporations and unions will be free to spend as much general treasury money as they wish on ads that support or attack specific candidates, whereas national parties will not be able to spend a dime of soft money on ads of any kind. The court's ruling thus dramatically enhances the role of corporations and unions and the narrow interests they represent, vis-a-vis the role of political parties, and the broad coalitions they represent in determining who will hold public office. Beyond the reliance interests at stake, the other stare decisis factors also cut against the court. Considerations of antiquity are significant for similar reasons. McConnell is only 6 years old, but Austin has been on the books for 2 decades, and many of the statutes called into question by today's opinion have been on the books for a half century or more. The court points to no intervening change in circumstances that warrants revisiting Austin. Certainly nothing relevant has changed since we decided Wordle 2 terms ago, and the court gives no reason to think that Austin and McConnell are unworkable. In fact, no one has argued to us that Austin's rule has proved impracticable, and not a single for-profit corporation, union, or state has asked us to overrule it. Quite to the contrary, leading groups representing the business community, organized labor, and the nonprofit sector, together with more than half of the states, urge that we preserve Austin. As for McConnell, the portions of BCRA it upheld may be prolix, but all 3 branches of government have worked to make subsection 203 as user-friendly as possible. For instance, Congress established a special mechanism for expedited review of constitutional challenges. The FEC has established a standardized process with clearly defined safe harbors for corporations to claim that a particular electioneering communication is permissible under Wordle. And, as noted above, the Chief Justice crafted his controlling opinion in Wordle with the express goal of maximizing clarity and administrability. The case for stare decisis may be bolstered, we have said, when subsequent rulings have reduced the impact of a precedent while reaffirming the decision's core ruling. In the end, the court's rejection of Austin and McConnell comes down to nothing more than its disagreement with their results. Virtually every one of its arguments was made and rejected in those cases, and the majority opinion is essentially an amalgamation of resuscitated dissents. The only relevant thing that has changed since Austin and McConnell is the composition of this court. Today's ruling thus strikes at the vitals of stare decisis, the means by which we ensure that the law will not merely change erratically, but will develop in a principled and intelligible fashion that permits society to presume that bedrock principles are founded in the law rather than in the proclivities of individuals. The novelty of the court's procedural dereliction and its approach to stare decisis is matched by the novelty of its ruling on the merits. The ruling rests on several premises. First, the court claims that Austin and McConnell have banned corporate speech. Second, it claims that the First Amendment precludes regulatory distinctions based on speaker identity, including the speaker's identity as a corporation. Third, it claims that Austin and McConnell were radical outliers in our First Amendment tradition and our campaign finance jurisprudence. Each of these claims is wrong. The so-called ban. Pervading the court's analysis is the ominous image of a categorical ban on corporate speech. Indeed, the majority invokes the specter of a ban on nearly every page of its opinion. This characterization is highly misleading and needs to be corrected. In fact, it already has been. Our cases have repeatedly pointed out that, contrary to the majority's critical assumptions, the statutes upheld in Austin and McConnell do not impose an absolute ban on all forms of corporate political spending. For starters, both statutes provide exemptions for PACs, separate segregated funds established by a corporation for political purposes. The ability to form and administer separate segregated funds, we observed in McConnell, has provided corporations and unions with a constitutionally sufficient opportunity to engage in express advocacy. That has been this court's unanimous view. Under BCRA, any corporation's stockholder in their families and its executive or administrative personnel and their families can pool their resources to finance electioneering communications. A significant and growing number of corporations avail themselves of this option. During the most recent election cycle, corporate and union PACs raised nearly $1 billion. Administering a PAC entails some administrative burden, but so does complying with the disclaimer, disclosure, and reporting requirements that the court today upholds. And no one has suggested that the burden is severe for a sophisticated for-profit corporation. To the extent the majority is worried about this issue, it is important to keep in mind that we have no record to show how substantial the burden really is, just the majority's own unsupported fact-finding. Like all other natural persons, every shareholder of every corporation remains entirely free under Austin and McConnell to do however much electioneering she pleases outside of the corporate form. The owners of a mom-and-pop store can simply place ads in their own name rather than the stores. If ideologically aligned individuals wish to make unlimited expenditures through the corporate form, they may utilize an MCFL organization that has policies in place to avoid becoming a conduit for business or union interests. The laws upheld in Austin and McConnell have opened many additional avenues for corporations' political speech. Consider the statutory provision we are ostensibly evaluating in this case, BCRA subsection 203. It has no application to genuine issue advertising, a category of corporate speech Congress found to be far more substantial than election-related advertising, or to internet, telephone, and print advocacy. Like numerous statutes, it exempts media companies' news stories, commentaries, and editorials from its electioneering restrictions in recognition of the unique role played by the institutional press in sustaining public debate. It also allows corporations to spend unlimited sums of political communications with their executives and shareholders, to fund additional PAC activity through trade associations, to distribute voting guides and voting records, to underwrite voter registration and voter turnout activities, to host fundraising events for candidates within certain limits, and to publicly endorse candidates through a press release and press conference. At the time Citizens United brought this lawsuit, the only types of speech that could be regulated under subsection 203 were 1. Broadcast cable or satellite communications, 2. Capable of reaching at least 50,000 persons in the relevant electorate, 3. Made within 30 days of a primary or 60 days of a general federal election, 4. By a labor union or a non-MCFL non-media corporation, 5. Paid for with general treasury funds, and 6. Susceptible of no reasonable interpretation other than an appeal to vote for or against a specific candidate. The category of communications meeting all of these criteria is not trivial, but the notion that corporate political speech has been suppressed altogether, that corporations have been excluded from the general public dialogue, or that a work of fiction such as Mr. Smith Goes to Washington might be covered is nonsense. Even the plaintiffs in McConnell, who had every incentive to depict BCRA as negatively as possible, declined to argue that subsection 203's prohibition on certain uses of general treasury funds amounts to a complete ban. In many ways, then, subsection 203 functions as a source restriction or a time, place, and manner restriction. It applies in a viewpoint-neutral fashion to a narrow subset of advocacy messages about clearly identified candidates for federal office, made during discrete time periods through discrete channels. In the case at hand, all Citizens United needed to do was broadcast Hillary right before the primary. All Citizens United needed to do to broadcast Hillary right before the primary was to abjure business contributions or use the funds in its PAC, which by its own account is one of the most active conservative PACs in America. So let us be clear, neither Austin nor McConnell held or implied that corporations may be silenced. The FEC is not a censor, and in the years since these cases were decided, corporations have continued to play a major role in the national dialogue. Laws such as subsection 203 target a class of communications that is especially likely to corrupt the political process, that is at least 1 degree removed from the views of individual citizens, and that may not even reflect the views of those who pay for it. Such laws burden political speech, and that is always a serious matter, demanding careful scrutiny. But the majority's incessant talk of a ban aims at a straw man: identity-based distinctions. The second pillar of the court's opinion is its assertion that the government cannot restrict political speech based on the speaker's identity. The case on which it relies for this proposition is First National Bank of Boston versus Bellotti. As I shall explain, the holding in that case was far narrower than the court implies. Like its peons to unfettered discourse, the court's denunciation of identity-based distinctions may have rhetorical appeal, but it obscures reality. Our jurisprudence over the past 216 years has rejected an absolutist interpretation of the First Amendment. The First Amendment provides that Congress shall make no law abridging the freedom of speech or of the press. Apart perhaps from measures designed to protect the press, that text might seem to permit no distinctions of any kind. Yet, in a variety of contexts, we have held that speech can be regulated differentially on account of the speaker's identity, when identity is understood in categorical or institutional terms. The government routinely places special restrictions on the special rights of students, prisoners, members of the armed forces, foreigners, and its own employees. When such restrictions are justified by a legitimate governmental interest, they do not necessarily raise constitutional problems. In contrast to the blanket rule that the majority espouses, our cases recognize that the government's interests may be more or less compelling with respect to different classes of speakers, and that the constitutional rights of certain categories of speakers in certain contexts are not automatically coexistive with the rights that are normally accorded to members of our society. The free speech guarantee thus does not render every other public interest an illegitimate basis for qualifying a speaker's autonomy. Society could scarcely function if it did. It is fair to say that our First Amendment doctrine has frowned upon certain identity-based distinctions, particularly those that may reflect invidious discrimination or preferential treatment of a politically powerful group. But it is simply incorrect to suggest that we have prohibited all legislative distinctions based on identity or content. Not even close. The election context is distinctive in many ways, and the court, of course, is right that the First Amendment closely guards political speech. But in this context, too, the authority of legislatures to enact viewpoint-neutral regulations based on content and identity is well settled. We have, for example, allowed state-run broadcasters to exclude independent candidates from televised debates. We have upheld statutes that prohibit the distribution or display of campaign materials near a polling place. Although we have not reviewed them directly, we have never cast doubt on laws that place special restrictions on campaign spending by foreign nationals, as we have consistently approved laws that bar government employees, but not others, from contributing to or participating in political activities. These statutes burden the political expression of one class of speakers, namely civil servants. Yet we have sustained them on the basis of long-standing practice and Congress's reasoned judgment that certain regulations which leave untouched full participation in political decisions at the ballot box help ensure that public officials are sufficiently free from improper influences, and that confidence in the system of representative government is not eroded to a disastrous extent. The same logic applies to this case with additional force because it is the identity of corporations rather than individuals that the legislature has taken into account. As we have unanimously observed, legislatures are entitled to decide that the special characteristics of the corporate structure require particularly careful regulation in an electoral context. Not only has the distinctive potential of corporations to corrupt the electoral process long been recognized, but within the area of campaign finance, corporate spending is also furthest from the core of political expression, since corporations' First Amendment speech and associations' interests are derived largely from those of their members and of the public in receiving information. Campaign finance distinctions based on corporate identity tend to be less worrisome, in other words, because the speakers are not natural persons, much less members of our political community, and the governmental interests are of the highest order. Furthermore, when corporations as a class are distinguished from non-corporations as a class, there is a lesser risk that regulatory distinctions will reflect invidious discrimination or political favoritism. If taken seriously, our colleagues' assumption that the identity of the speaker has no relevance to the government's ability to regulate political speech that would lead to some remarkable conclusions. Such an assumption would have accorded the propaganda broadcasts to our troops by Tokyo Rose during World War II the same protection as by Allied commanders. More pertinently, it would appear to afford the same protection to multinational corporations controlled by foreigners as to individual Americans. To do otherwise, after all, could enhance the relative vote of some, i.e. humans, over others, i.e. non-humans. Under the majority's view, I suppose it may be a First Amendment problem that corporations are not permitted to vote, given that voting is, among other things, a form of speech. In short, the court dramatically overstates its critique of identity-based distinctions, without ever explaining why corporate identity demands the same treatment as individual identity. Only the most wooden approach to the First Amendment could justify the unprecedented line it seeks to draw. our First Amendment tradition. A third fulcrum of the court's opinion is the idea that Austin and McConnell are radical outliers, aberrations in our First Amendment tradition. The court has it exactly backwards. It is today's holding that is the radical departure from what has been settled First Amendment law. To see why, it is useful to take a long view. Original understandings. Let us start from the beginning. The court invokes ancient First Amendment principles and original understandings to defend today's ruling, yet it makes only a perfunctory attempt to ground its analysis in the principles or understandings of those who drafted and ratified the amendment. Perhaps this is because there is not a scintilla of evidence to support the notion that anyone believed it would preclude regulatory distinctions based on the corporate form. To the extent that the framers' views are discernible and relevant to the disposition of this case, they would appear to cut strongly against the majority's position. This is not only because the framers and their contemporaries conceived of speech more narrowly than we now think of it, but also because they held different views about the nature of the First Amendment right and the role of corporations in society. Those few corporations that exist at the founding were authorized by grant of a special legislative charter. Corporate sponsors would petition the legislature, and the legislature, if amenable, would issue a charter that specified the corporation's powers and purposes and authoritatively fixed the scope and content of corporate organization, including the internal structure of the corporation. Corporations were created, supervised, and conceptualized as quasi-public entities, designed to serve a social function for the state. It was assumed that they were legally privileged organizations that had to be closely scrutinized by the legislature because their purpose had to be made consistent with public welfare. The individualized character mode of incorporation reflected the cloud of disfavor under which corporations labored in the early years of this nation. Thomas Jefferson famously fretted that corporations would subvert the republic. General incorporation statutes and widespread acceptance of business corporations as socially useful actors did not emerge until the 1800s. The framers thus took it as a given that corporations could be comprehensively regulated in the service of the public welfare. Unlike our colleagues, they had little trouble distinguishing corporations from human beings, and when they constitutionalized the right to free speech in the First Amendment, it was the free speech of individual Americans that they had in mind. While individuals might join together to exercise their speech rights, business corporations, at least, were plainly not seen as facilitating such association or expressive ends. Even the notion that business corporations could invoke the First Amendment would probably have been quite a novelty, given that at the time the legitimacy of every corporate activity was thought to rest entirely on a concession of the sovereign. In light of these background practices and understandings, it seems to me implausible that the framers believed the freedom of speech would extend equally to all corporate speakers, much less that it would preclude legislatures from taking limited measures to guard against corporate capture of elections. The court observes that the framers drew on diverse intellectual sources, communicated through newspapers, and aimed to provide greater freedom of speech that had existed in England. From these accurate observations, the court concludes that the First Amendment was certainly not understood to condone the suppression of political speech in society's most salient media. This conclusion is far from certain, given that many historians believe the framers were focused on prior restraints on publication and did not understand the First Amendment to prevent the subsequent punishment of such publications as may be deemed contrary to the public welfare. Yet even if the majority's conclusion were correct, it would tell us only that the First Amendment was understood to protect political speech in certain media. It would tell us little about whether the amendment was understood to protect general Treasury electioneering expenditures by corporations, and to what extent. As a matter of original expectations, then, it seems absurd to think that the First Amendment prohibits legislatures from taking into account the corporate identity of a sponsor of electoral advocacy. As a matter of original meaning, it likewise seems baseless unless one evaluates the First Amendment's principles or its purpose at such a high level of generality that the historical understandings of the amendment cease to be a meaningful constraint on the judicial task. This case sheds a revelatory light on the assumption of some that an impartial judge's application of an originalist methodology is likely to yield more determinate answers, or to play a more decisive role in the decision process than his or her views about sound policy. Justice Scalia criticizes the foregoing discussion for failing to adduce the statements from the founding era showing that corporations were understood to be excluded from the First Amendment's free speech guarantee. Of course, Justice Scalia adduces no statements to suggest the contrary proposition, or even to suggest that the contrary proposition better reflects the kind of right that the drafters and ratifiers of the Free Speech Clause thought they were enshrining. Although Justice Scalia makes a perfectly sensible argument that an individual's right to speak entails a right to speak with others for a common cause, he does not explain why those two rights must be precisely identical, or why that principle applies to electioneering by corporations that serve no common cause. Nothing in his account dislodges my basic point that members of the founding generation held a cautious view of corporate power and a narrow view of corporate rights. Not that they despised corporations and that they conceptualized speech in individualistic terms. If no prominent framer bothered to articulate that corporate speech would have lesser status than individual speech, that may well be because the contrary position, if not the very notion of corporate speech, was inconceivable. Justice Scalia also emphasizes the unqualified nature of the First Amendment text. Yet he would seemingly read out the Free Press Clause. How else could he claim that my purported views on newspapers must track my views on corporations generally? Like virtually all modern lawyers, Justice Scalia presumably believes that the First Amendment restricts the executive, even though its language refers to Congress alone. In any event, the text only leads us back to the questions who or what is guaranteed the freedom of speech, and just as critically, what that freedom consists of, and under what circumstances it may be limited. Justice Scalia appears to believe that because corporations are created and utilized by individuals, it follows, as night the day, that their electioneering must be equally protected by the First Amendment and equally immunized from expenditure limits. That conclusion certainly does not follow as a logical matter, and Justice Scalia fails to explain why the original public meaning leads it to follow as a matter of interpretation. The truth is we cannot be certain how a law such as BCRA subsection 203 meshes with the original meaning of the First Amendment. I have given several reasons why I believe the Constitution would have been understood then and ought to be understood now to permit reasonable restrictions on corporate electioneering, and I will give many more reasons in the pages to come. The court enlists the framers in its defense without seriously grappling with their understanding of corporations or the free speech right, or with the Republican principles that underlay those understandings. In fairness, our campaign finance jurisprudence has never attended very closely to the views of the framers, whose political universe differed profoundly from that of today. We have long since held that corporations are covered by the First Amendment, and many legal scholars have long since rejected the concession theory of the corporation. But historical context is usually relevant. In the light of the court's effort to cast itself as guardian of ancient values, it pays to remember that nothing in our constitutional history dictates today's outcome. To the contrary, this history helps illuminate just how extraordinarily dissonant the decision is. Legislative and judicial interpretation. A century of more recent history puts to rest any notion that today's ruling is faithful to our First Amendment tradition. At the federal level, the express distinction between corporate and individual political spending on elections stretches back to 1907, when Congress passed the Tillman Act, banning all corporate contributions to candidates. The Senate report on the legislation observed that the evils of the use of corporate money in connection with political elections are so generally recognized that the committee deems it unnecessary to make any argument in favor of the general purpose of this measure. It is in the interest of good government and calculated to promote purity in the selection of public officials. President Roosevelt, in his 1905 annual message to Congress, declared, "All contributions by corporations to any political committee or for any political purpose should be forbidden by law. Directors should not be permitted to use stockholders' money for such purposes, and moreover, a prohibition of this kind would be, as far as it went, an effective method of stopping the evils aimed at in Corrupt Practices Acts." The court has surveyed the history leading up to the Tillman Act several times, and I will refrain from doing so again. It is enough to say that the act was primarily driven by two pressing concerns. First, the enormous power corporations had come to wield in federal elections, with the accompanying threat of both actual corruption and a public perception of corruption. And second, a respect for the interests of shareholders and members in preventing the use of their money to support candidates they oppose. Over the years, the limitations on corporate political spending have been modified in a number of ways, as Congress responded to changes in the American economy and political practices that threatened to displace the the Commonweal. Justice Souter recently traced these developments at length. The Taft-Hartley Act of 1947 is of special significance for this case. In that act, passed more than 60 years ago, Congress extended the prohibition on corporate support for candidates to cover not only direct contributions, but independent expenditures as well. The bar on contributions was being so narrowly construed that corporations were easily able to defeat the purposes of the act by supporting candidates through other means. Our colleagues emphasized that in two cases from the middle of the 20th century, several justices wrote separately to criticize the expenditure restriction as applied to unions, even though the court declined to pass on its constitutionality. Two features of these cases are of far greater relevance. First, those justices were writing separately, which is to say their position failed to command a majority. Prior to today, this was a fact we found significant in evaluating precedents. Second, each case in this line expressed support for the principle that corporate and union political speech financed with PAC funds collected voluntarily from the organization's stockholders or members receives greater protection than speech financed with general treasury funds. This principle was carried forward when Congress enacted Comprehensive Campaign Finance Reform in the Federal Election Campaign Act of 1971, which retained the restriction on using general treasury funds for contributions and expenditures. FECA codified the opinion for corporations and unions to create PACs to finance contributions and expenditures forbidden to the corporation or union itself. By the time Congress passed FECA in 1971, the bar on corporate contributions and expenditures had become such an accepted part of federal campaign finance regulation that when a large number of plaintiffs, including several nonprofit corporations, challenged virtually every aspect of FECA in Buckley, no one even bothered to argue that the bar was was unconstitutional. Buckley famously or infamously distinguished direct contributions from independent expenditures, but its silence on corporations only reinforced the understanding that corporate expenditures could be treated differently from individual expenditures. Since our decision in Buckley, Congress's power to prohibit corporations and unions from using funds in their treasuries to finance advertisements expressly advocating the election or defeat of candidates in federal elections has been firmly embedded in our law. Thus, it was unremarkable in a 1982 case holding that Congress could bar nonprofit corporations from soliciting non-members for PAC funds. That then Justice Rehnquist wrote for a unanimous court that Congress's careful legislative adjustment of the federal electoral laws in a cautious advance, step by step, to account for the particular legal and economic attributes of corporations warrants considerable deference, and reflects a permissible assessment of the dangers posed by those entities to the electoral process. The governmental interest in preventing both actual corruption and the appearance of corruption of elected representatives has long been recognized, the unanimous court observed, and there is no reason why it may not be accomplished by treating corporations differently from individuals. The corporate-individual distinction was not questioned by the court's disposition in 1986 as of a challenge to the expenditure restriction as applied to a distinctive type of nonprofit corporation. In MCFL, we stated that the special characteristics of the corporate structure require particularly careful regulation, and again we acknowledged that the government has a legitimate interest in regulating the substantial aggregations of wealth amassed by the special advantages which go with the corporate form. Those aggregations can distort the free trade in ideas crucial to candidate elections, at the expense of members or shareholders who may disagree with the object of the expenditures. What the court held by a 5-4 vote was that a limited class of corporations must be allowed to use their general treasury funds for independent expenditures because Congress's interest in protecting shareholders and restricting the influence of political war chests funneled through the corporate form did not apply to corporations that were structurally insulated from those concerns. It is worth remembering for present purposes that the four MCFL dissenters, led by Chief Justice Rehnquist, thought the court was carrying the First Amendment too far. They would have recognized congressional authority to bar general treasury electioneering expenditures even by this class of nonprofits. They acknowledged that the threat from corporate political activity will vary depending on the particular characteristics of a given corporation, but believed these distinctions among corporations were distinctions in degree, not in kind, and thus more properly drawn by the legislature than by the judiciary. Not a single justice suggested that regulation of corporate political speech would be no more stringent than of speech by an individual. 4 years later in Austin, we considered whether corporations falling outside of MCFL exception could be barred from using general Treasury funds to make independent expenditures in support of or in opposition to candidates. We held they could be. Once again, recognizing the importance of the integrity of the marketplace of political ideas in candidate elections, we noted that corporations have special advantages such as limited liability, perpetual life, and favorable treatment of the accumulation and distribution of assets that allow them to spend prodigious general treasury sums on campaign messages that have little or no correlation with the beliefs held by actual persons. In light of the corrupting effects such spending might have on the political process, we permitted the state of Michigan to limit corporate expenditures on candidate elections to corporate PACs, which rely on voluntary contributions and thus reflect actual public support for the political ideas espoused by corporations. Notwithstanding our colleagues' insinuations that Austin deprived the public of general ideas, facts, and knowledge, the decision addressed only candidate-focused expenditures and gave the state no license to regulate corporate spending on other matters. In the 20 years since Austin, we have reaffirmed its holding and rationale a number of times. Most importantly, in McConnell, where we upheld the provision challenged here. Congress crafted subsection 203 in response to a problem created by Buckley. The Buckley court had construed FECA's definition of prohibited expenditures narrowly to avoid any problems of constitutional vagueness, holding it applicable only to communications that expressly advocate the election or defeat of a clearly identified candidate. Statements containing so-called magic words like vote for, elect, support, cast your ballot for, Smith for Congress, vote against, defeat, or reject. After Buckley, corporations and unions figured out how to circumvent the limits on express advocacy by using sham issue ads that eschewed the use of magic words but nonetheless advocated the election or defeat of clearly identified federal candidates. Corporations and unions spent hundreds of millions of dollars of their general funds to pay for these ads. Congress passed subsection 203 to address this circumvention, prohibiting corporations and unions from using general treasury funds for electioneering communications that refer to a clearly identified candidate, whether or not those communications use the magic words. When we asked in McConnell whether a compelling governmental interest justified subsection 203, we found the question easily answered. We have repeatedly sustained legislation aimed at the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public support for the corporation's political ideas. These precedents represent respect for the legislative judgment that the special characteristics of the corporate structure require particularly careful regulation. Moreover, recent cases have recognized that certain restrictions on corporate electoral involvement permissibly hedge against circumvention of valid contribution limits. BCRA, we found, is faithful to the compelling governmental interest in preserving the integrity of the electoral process, preventing corruption, sustaining the active, alert responsibility of the individual citizen in a democracy for the wise conduct of the government, and maintaining the individual citizen's confidence in government. What made the answer even easier than it might have been otherwise was the option to form PACs, which give corporations at the least a constitutionally sufficient opportunity to engage in independent expenditures. Buckley and Bellotti. Against this extensive background of congressional regulation of corporate campaign spending and our repeated affirmation of this regulation as constitutionally sound, the majority dismisses Austin as a significant departure from ancient First Amendment principles. How does the majority attempt to justify this claim? Selected passages from two cases, Buckley and Bellotti, do all of the work. In the court's view, Buckley and Bellotti decisively rejected the possibility of distinguishing corporations from natural persons in the 1970s. It just so happens that in every single case in which the court has reviewed campaign finance legislation in the decades since, the majority failed to grasp this truth. The federal Congress and dozens of state legislatures we now know have been similarly deluded. The majority emphasizes Buckley's statement that the concept that government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment. But this elegant phrase cannot bear the weight that our colleagues have placed on it. For one thing, the Constitution does in fact permit numerous restrictions on the speech of some in order to prevent a few from drowning out the many. For example, restrictions on ballot access and on legislatures' floor time. For another, the Buckley court used this line in evaluating the ancillary governmental interest in equalized in equalizing the relative ability of individuals and groups to influence the outcome of elections. It is not apparent why this is relevant to the case before us. The majority suggests that Austin rests on the foreign concept of speech equalization, but we made it clear in Austin, as in several cases before and since, that a restriction on the way corporations spend their money is no mere exercise in disfavoring the voice of some elements of our society in preference to others. Indeed, we expressly ruled that the compelling interest supporting Michigan's statute was not one of equalizing the relative influence of speakers on elections, but rather the need to confront the distinctive corrupting potential of corporate electoral advocacy financed by general treasury dollars. For that matter, it should go without saying that when we made this statement in Buckley, we could not have been casting doubt on the restrictions on corporate expenditures in candidate elections, which had not been challenged as foreign to the First Amendment, or for any other reason. Buckley's independent expenditure analysis was found on a very different statutory provision. It is implausible to think, as the majority suggests, that Buckley covertly invalidated FECA's separate corporate and union campaign expenditure restriction, even though that restriction had been on the books for decades before Buckley and would remain on the books undisturbed for decades after. The case on which the majority places even greater weight than Buckley, however, is Bellotti, claiming it could not have been clearer that Bellotti's holding forbade distinctions between corporate and individual expenditures like the one at issue here. The court's reliance is odd. The only thing about Bellotti that could not be clearer is that it declined to adopt the majority's position. Bellotti ruled in an explicit limitation on the scope of its holding that our consideration of a corporation's right to speak on issues of general public interest implies no comparable right in the quite different context of participation in a political campaign for election to public office. Bellotti, in other words, did not touch the question presented in Austin and McConnell, and the opinion squarely disavowed the proposition for which the majority cites it. The majority attempts to explain away the distinction Bellotti drew between general corporate speech and campaign speech intended to promote or prevent the election of specific candidates for office, as inconsistent with the rest of the opinion and with Buckley. Yet the basis for this distinction is perfectly coherent. The anti-corruption interests that animate regulations of corporate participation in candidate elections, the importance of which has never been doubted, do not apply equally to regulations of corporate participation in referenda. A referendum cannot owe a political debt to a corporation, seek to curry favor with a corporation, or fear the corporation's retaliation. The majority likewise overlooks the fact that over the past 30 years, our cases have repeatedly recognized the candidate issue distinction. The court's critique of Bellotti's footnote 26 puts it in the strange position of trying to elevate Bellotti to canonical status, while simultaneously disparaging a critical piece of its analysis. The court's critique of Bellotti's footnote 26 puts in the strange position of trying to elevate Bellotti to canonical status, while simultaneously disparaging a critical piece of its analysis as unsupported and irreconcilable with Buckley. Bellotti apparently is both the font of all wisdom and internally incoherent. The Bellotti court confronted a dramatically different factual situation from the one that confronts us in this case, a state statute that barred business corporations' expenditures on some referenda but not others. Specifically, the statute barred a business corporation from making contributions or expenditures for the purpose of influencing or affecting the vote or on any question submitted to the voters other than one materially affecting any of the property, business, or assets of the corporation. And it went so far as to provide that referenda related to income taxation would not be deemed materially to affect the property, business, or assets of the corporation. As might be guessed, the legislature had enacted this statute in order to limit corporate speech on a proposed state constitutional amendment to authorize a graduated income tax. The statute was a transparent attempt to prevent corporations from spending money to defeat this amendment, which was favored by a majority of legislatures but had been repeatedly rejected by the voters. We said that whereas here the legislature's suppression of speech suggests an attempt attempt to give one side of the debate of a debatable public question an advantage in expressing its views to the people, the First Amendment is plainly offended. Bellotti thus involved a viewpoint discriminatory statute created to affect a particular policy outcome. Even Justice Rehnquist in dissent had to acknowledge that a very persuasive argument could be made that the Massachusetts legislature, desiring to impose a personal income tax, but more than once defeated in that desire by the combination of the Commonwealth's referendum provision and corporate expenditures in opposition to such a tax, simply decided to muzzle corporations on this sort of issue so that it could succeed in its desire. To make matters worse, the law at issue did not make any allowance for corporations to spend money through PACs. This really was a complete ban on a specific pre-identified subject. The majority grasps a quotation straw from Bellotti that speech does not fall entirely outside the protection of the First Amendment merely because it comes from a corporation. Of course not, but no one suggested to the contrary, and neither Austin nor McConnell held otherwise. They held that even though the expenditures at issue were subject to First Amendment scrutiny, the restrictions on those expenditures were justified by compelling state interests. We acknowledged in Bellotti that numerous interests of the highest importance can justify campaign finance regulation, but we found no evidence that these interests were served by the Massachusetts law. We left open the possibility that our decision might have been different if there had been record or legislative findings that corporate advocacy threatens imminently to undermine the democratic processes, thereby denigrating rather than serving First Amendment interests. Austin and McConnell then sit perfectly well with Bellotti. Indeed, all 6 members of the Austin majority had been on the court at the time of Bellotti, and none so much as hinted that in Austin that they saw any tension between the decisions. The difference between the cases is not that Austin and McConnell rejected First Amendment protection for corporations, whereas Bellotti accepted it. The difference is that the statute at issue in Bellotti smacked of viewpoint discrimination, targeted one class of corporations, and provided no PAC option, and the state has a greater interest in regulating independent corporate expenditures on candidate elections than on referenda, because in a functioning democracy, the public must have faith that its representatives owe their positions to the people, not to the corporations with the deepest pockets. In sum, over the course of the past century, Congress has demonstrated a recurrent need to regulate corporate participation in candidate elections to preserve the integrity of the electoral process, prevent corruption, sustain the active, alert responsibility of the individual citizen, protect the expressive interests of shareholders, and preserve the individual citizen's confidence in government. These understandings provided the combined impetus behind the Tillman Act in 1907. Continuously for over 100 years, this line of campaign finance reform has been a series of reactions to documented threats to electoral integrity obvious to any voter, posed by large sums of money from corporate or union treasuries. Time and again, we have recognized these realities in approving measures that Congress and the states have taken. None of the cases the majority cites is to the contrary. The only thing new about Austin was the dissent, with its stunning failure to appreciate the legitimacy of interests recognized in the name of democratic integrity since the days of the progressives. Having explained why this is not an appropriate case in which to revisit Austin and McConnell, and why these decisions sit perfectly well with First Amendment principles, I come at last to the interests that are at stake. The majority recognizes that Austin and McConnell may be defended on anti-corruption, anti-distortion, and shareholder protection rationales. It badly errs both in explaining the nature of these rationales, which overlap and complement each other, and in applying them to the case at hand. The anti-corruption interest. Undergirding the majority's approach to the merits is the claim that only sufficiently important governmental interests in preventing corruption or the appearance of corruption is one that is limited to quid pro quo corruption. This is the same crabbed view of corruption that was espoused by Justice Kennedy in McConnell and squarely rejected by the court in that case. While it is true that we have not always spoken about corruption in a clear or consistent voice, the approach taken by the majority cannot be right, in my judgment. It disregards our constitutional history and the fundamental demands of a democratic society. On numerous occasions, we have recognized Congress's legitimate interest in preventing the money that is spent on elections from exerting an undue influence on an office holder's judgment, and from creating the appearance of such influences beyond the sphere of quid pro quo relationships. Corruption can take many forms. Bribery may be the paradigm case, but the difference between selling a vote and selling access is a matter of degree, not kind. And selling access is not qualitatively different from giving special preference to those who spent money on one's behalf. Corruption operates along a spectrum, and the majority's apparent belief that quid pro quo arrangements can be neatly demarcated from other improper influences does not accord with the theory or reality of politics. It certainly does not accord with the record Congress developed in passing BCRA, a record that stands as a remarkable testament to the energy and ingenuity with which corporations and unions, lobbyists, and politicians may go about scratching each other's backs, and which amply supported Congress's determination to target a limited set of especially destructive practices. The district court that adjudicated the initial challenge to BCRA pored over this record. In a careful analysis, Judge Kohler-Cotley made numerous findings about the corruption consequences of corporate and union independent expenditures in the years preceding BCRA's passage. As summarized in her own words, the factual findings of the court illustrate that corporations and labor unions routinely notify members of Congress as soon as they air electioneering communication relevant to the members' elections. The records also indicate that members express appreciation to organizations for the airing of these election-related advertisements. Indeed, members of Congress are particularly grateful when negative issue advertisements are run by these organizations, leaving the candidates free to run positive advertisements and be seen as above the fray. Political consultants testify that campaigns are quite aware of who is running advertisements on the candidate's behalf, when they are being run and where they are being run. Likewise, a prominent lobbyist testified that these organizations use issue advocacy as a means to influence various members of Congress. The findings also demonstrate that members of Congress seek to have corporations and unions run these advertisements on their behalf. The findings show that members suggest that corporations or individuals make donations to interest groups with the understanding that the money contributed to these groups will assist the member in a campaign. After the election, these organizations often seek credit for their support. Finally, a large majority of Americans, 80%, are of the view that corporations and other organizations that engage in electioneering communications, which benefit specific elected officials, receive special consideration from those officials when matters arise that affect these corporations and organizations. Many of the relationships of dependency found by Judge Kohler-Cotley seem to have a quid pro quo basis, but other arrangements were more subtle. Her analysis shows the great difficulty in delimiting the precise scope of the quid pro quo category, as well as the adverse consequences that all such arrangements may have. There are threats of corruption that are far more destructive to a democratic society than the odd bribe. Yet the majority's understanding of corruption would leave lawmakers impotent to address all but the most discreet abuses. Our undue influence cases have allowed the American people to cast a wider net through legislative experiments designed to ensure, to some minimal extent, that office holders will decide issues on the merits or the desires of their constituencies, and not according to the wishes of those who have made large financial contributions or expenditures valued by the office holder. When private interests are seen to exert outsized control over office holders solely on account of the money spent on or withheld from their campaigns, the result can depart so thoroughly from what is pure or correct in the conduct of government, that it amounts to a subversion of the electoral process. At stake in the legislative efforts to address this threat is therefore not only the legitimacy and quality of government, but also the public's faith therein. Not only the capacity of this democracy to represent its constituents, but also the confidence of its citizens in their capacity to govern themselves. Take away Congress's authority to regulate the appearance of undue influence, and the cynical assumption that large donors call the tune would jeopardize the willingness of voters to take part in democratic governance. The cluster of interrelated interests threatened by such undue influence and its appearance has been well captured under the rubric of democratic integrity. This value has underlined a century of state and federal efforts to regulate the role of corporations in the electoral process. Unlike the majority's myopic focus on quid pro quo scenarios and the free-floating First Amendment principles on which rests so much weight, this broader understanding of corruption has deep roots in the nation's history. During debates on the earliest Campaign Finance Reforms Act, the terms corruption and undue influence were used nearly interchangeably. Long before Buckley, we appreciated that to say that Congress is without power to pass appropriate legislation to safeguard an election from the improper use of money to influence the result is to deny to the nation in a vital particular the power of self-protection. Let me read that. An election from the improper use of money to influence the result is to deny to the nation in a vital particular the power of self-protection. And whereas we have no evidence to support the notion that the framers would have wanted corporations to have the same rights as natural persons in the electoral context, we have ample evidence to suggest that they would have been appalled by the evidence of corruption that Congress unearthed in developing BCRA, and that the court today discounts to irrelevance. It is fair to say that the framers were obsessed with corruption, which they understood to encompass the dependency of public office holders on private interests. They discussed corruption more often in the Constitutional Convention than factions, violence, or instability. When they brought our constitutional order into being, the framers had their minds trained on a threat to Republican self-government that this court has lost sight of: quid pro quo corruption. There is no need to take my side in the debate over the scope of the anti-corruption interest to see that the court's merits holding is wrong. Even under the majority's crabbed view of corruption, the government should not lose this case. The importance of the governmental interest in preventing corruption through the creation of political debts has never been doubted. Even in the cases that have construed the anti-corruption interest most narrowly, we have never suggested that such quid pro quo debts must take the form of outright vote buying or bribes, to which have long been distinct crimes. Rather, they encompass the myriad ways in which outside parties may induce an officeholder to confer a legislative benefit in direct response to or anticipation of some outlay of money the parties have made or will make on behalf of the officeholder. We have not limited the anti-corruption interest to the elimination of cash for votes exchanges. In Buckley, we expressly rejected the argument that anti-bribery laws provided a less restrictive alternative to FCCA's contribution limits, noting that such laws dealt with only the most blatant and specific attempts of those with money to influence governmental action. It has likewise never been doubted that of almost equal concern as the danger of actual quid pro quo arrangements is the impact of the appearance of corruption. Congress may legitimately conclude that the avoidance of the appearance of improper influence is also critical, if confidence in the system of representative government is not to be eroded to a disastrous extent. A democracy cannot function effectively when its constituent members believe laws are being bought and sold. In theory, our colleagues accept this as much. As applied to BCRA subsection 203, however, they conclude the anti-corruption interest is not sufficient to displace the speech here in question. Although the court suggests that Buckley compels its conclusion, Buckley cannot sustain this reading. It is true that in evaluating FECA's ceiling on independent expenditures by all persons, the Buckley court found the governmental interest in preventing corruption inadequate. But Buckley did not evaluate corporate expenditures specifically, nor did it rule out the possibility that a future court might find otherwise. The opinion reasoned that an expenditure limitation covering only express advocacy, i.e. magic words, would likely be ineffectual, a problem that Congress tackled in BCRA, and it concluded that the independent advocacy restricted by FECA subsection 608E1 does not presently appear to pose dangers of real or apparently does not presently appear to pose dangers of real or apparent corruption comparable to those identified with large campaign contributions. Buckley expressly contemplated that an anti-corruption rationale might justify restrictions on independent expenditures at a later date, because it may be that in some circumstances, large independent expenditures pose the same dangers of actual or apparent quid pro quo arrangements as do large contributions. Certainly, Buckley did not foreclose this possibility with respect to electioneering communications made with corporate general treasury funds, an issue the court had no occasion to consider. The Austin court did not rest its holding on quid pro quo corruption, as it as it found the broader corruption implicated by the anti-distortion and shareholder protection rationales a sufficient basis for Michigan's restriction on corporate electioneering. Concurring in that opinion, I took the position that the danger of either the fact or the appearance of quid pro quo relationships also provides an adequate justification for state regulation of these independent expenditures. I did not see this position as inconsistent with Buckley's analysis of individual expenditures. Corporations as a class tend to be more attuned to the complexities of the legislative process and more directly affected by tax and appropriations measures that receive little public scrutiny. They also have vastly more money with which to try to buy access and votes. Business corporations must engage the political process in instrumental terms if they are to maximize shareholder value. The unparalleled resources, professional lobbyists, and single-minded focus they bring to this effort, I believe, make quid pro quo corruption and its appearance inherently more likely when they or their conduits or trade groups spend unrestricted sums on elections. It is with regret rather than satisfaction that I can now say that time has borne out my concerns. The legislative and judicial proceedings relating to BCRA generated a substantial body of evidence suggesting that as corporations grew more and more adept at crafting issue ads to help or harm a particular candidate, these nominally independent expenditures began to corrupt the political process in a very direct sense. The sponsors of these ads were routinely granted special access after the campaign was over. Candidates and officials knew who their friends were. Many corporate independent expenditures, it seemed, had become essentially interchangeable with direct contributions in their capacity to generate quid pro quo arrangements. In an age in which money and television ads are the coin of the campaign realm, it is hardly surprising that corporations deployed these ads to curry favor with or to gain influence over public officials. The majority appears to think it decisive that the BCRA record does not contain direct examples of votes being exchanged for expenditures. It would have been quite remarkable if Congress had created a record detailing such behavior by its own members. Proving that a specific vote was exchanged for a specific expenditure has always been next to impossible. Elected officials have diverse motivations, and no one will acknowledge that he sold a vote. Yet, even if ingratiation and access are not corruption themselves, they are necessary prerequisites to it. They can create both the opportunity for and the appearance of quid pro quo arrangements. The influx of unlimited corporate money into the electoral realm also creates new opportunities for the mirror image of quid pro quo deals, threats both explicit and implicit. Starting today, corporations with large war chests to deploy on electioneering may find democratically elected bodies becoming much more attuned to their interests. The majority both misreads the facts and draws the wrong conclusions when it suggests that the BCRA record provides only scant evidence that independent expenditures ingratiate and that, in any event, none of it matters. In her analysis of the record, Judge Kohler-Cottley documented the pervasiveness of this ingratiation and explained its significance under the majority's own touchstone for defining the scope of the anti-corruption rationale. Witnesses explained how political parties and candidates used corporate independent expenditures to circumvent FECA's hard money limitations. One former senator candidly admitted to the district court that candidates whose campaigns benefit from phony issue ads greatly appreciate the help of these groups. In fact, members will also be favorably disposed to those who finance these groups when they later seek access to discuss pending legislation. One prominent lobbyist went so far as to state in uncontroverted testimony that unregulated expenditures, whether soft money donations to the parties or issue ad campaigns, can sometimes generate far more influence than direct campaign contributions. In sum, Judge Kohler-Cottley found the record powerfully demonstrates that electioneering communications paid for with the general treasury funds of labor unions and corporations endears those entities to elected officials in a way that could be perceived by the public as corrupting. She concluded that the government's interest in preventing the appearance of corruption, as that concept was defined in Buckley, was itself sufficient to uphold BCRA subsection 203. When the McConnell Court affirmed the judgment of the District Court regarding subsection 203, we did not rest our holding on a narrow notion of quid pro quo corruption. Instead, we relied on the governmental interest in combating the unique forms of corruption threatened by corporations as recognized in Austin's anti-distortion and shareholder protection rationales. as well as the interest in preventing circumvention of contribution limits. Had we felt constrained by the view of today's court that quid pro quo corruption and its appearance are the only interests that count in this field, we of course would have looked closely at that issue. And as the analysis by Judge Collar-Cotterly reflects, it is a very real possibility that we would have found one or both of these interests satisfied and subsection 203 appropriately tailored to them. The majority's rejection of the Buckley anti-corruption rationale on the ground that independent corporate expenditures do not give rise to quid pro quo corruption or the appearance of corruption is thus unfair as well as unreasonable. Congress and outside experts have generated significant evidence corroborating this rationale, and the only reason we do not have any of the relevant materials before us is that the government has no reason to develop a record at trial for a facial challenge the plaintiff had abandoned. The court cannot both sua sponte choose to relitigate McConnell on appeal and then complain that the government has failed to substantiate its case. If our colleagues were really serious about the interest in preventing quid pro quo corruption, they would remand to the district court with instructions to commence evidentiary proceedings. The insight that even technically independent expenditures can be corrupting in much the same way as direct contributions is bolstered by our decision last year in Caperton v. A.T. Masley Coal Company. In that case, Don Blankenship, the chief executive officer of a corporation with a lawsuit pending before the West Virginia High Court, spent large sums on behalf of a particular candidate, Brent Benjamin, running for a seat on that court. In addition to contributing the $1,000 statutory maximum to Benjamin's campaign committee, Blankenship donated almost $2.5 million to And for the Sake of the Kids, a subsection 527 corporation that ran ads targeting Benjamin's opponent. This was not all. Blankenship spent, in addition, just over $500,000 on independent expenditures to support Brent Benjamin. Applying its common sense, this court accepted petitioner's argument that Blankenship's pivotal role in getting Justice Benjamin elected created a constitutionally intolerable probability of actual bias, when Benjamin later declined to recuse himself from the appeal by Blankenship's corporation. Though no bribe or criminal influence was involved, we recognize that Justice Benjamin would nevertheless feel a debt of gratitude to Blankenship for his extraordinary efforts to get him elected. The difficulties of inquiring into actual bias, we further noted, simply underscore the need for objective rules which will perforce turn on the appearance of bias rather than its actual existence. In Caperton, then, we accepted the premise that, at least in some circumstances, independent expenditures on candidate elections will raise an intolerable specter of quid pro quo corruption. Indeed, this premise struck the court as so intuitive that it repeatedly referred to Blankenship's spending on behalf of Benjamin, spending that consisted of 99.97 independent expenditures, $3 million, and 0.03% direct contributions, $1,000, as a contribution. The basis for the recusal motion was that the justice had received campaign contributions in an extraordinary amount from Blankenship. The reason the court so thoroughly conflated expenditures and contributions, one assumes, is that it realized that some expenditures may be functionally equivalent to contributions in the way they influence the outcome of a race, the way they are interpreted by the candidates and the public, and the way they taint the decisions that the office holder thereafter takes. Caperton is illuminating in several additional respects. It underscores the old insight that, on account of the extreme difficulty of proving corruption, prophylactic measures reaching some campaign spending are not corrupt in purpose. Prophylactic measures reaching some campaign spending not corrupt in purpose or effect may be nonetheless required to guard against corruption. It underscores that certain restrictions on corporate electoral involvement may likewise be needed to hedge against circumvention of valid contribution limits. It underscores that for-profit corporations associated with electioneering communications will often prefer to use nonprofit conduits with misleading names such as And for the Sake of the Kids to conceal their identity as the sponsor of those communications, thereby frustrating the utility of disclosure laws. And it underscores that the consequence of today's holding will not be limited to the legislative or executive context. The majority of the states select their judges through popular elections. At a time when concerns about the conduct of judicial elections have reached a fever pitch, This is let me just start over. And it underscores that the consequence of today's holding will not be limited to the legislative or executive context. The majority of the states select their judges through popular elections. At a time when concerns about the conduct of judicial elections have reached a fever pitch, the court today unleashes the floodgates of corporate and union general treasury spending in these races. Perhaps Caperton motions will catch some of the worst abuses. This will be small comfort to those states that, after today, may no longer have the ability to place modest limits on corporate electioneering, even if they believe such limits to be critical to maintaining the integrity of their judicial systems. Deference and incumbent self-protection. Rather than show any deference to a coordinate branch of government, the majority thus rejects the anti-corruption rationale without serious analysis. Today's opinion provides no clear rationale for being so dismissive of Congress, but the prior individual opinions on which it relies have offered one, the incentive of the legislatures who passed BCRA. Section 203, our colleagues have suggested, may be little more than an incumbency protection plan. A disreputable attempt at legislative self-dealing rather than an earnest effort to facilitate First Amendment values and safeguard the legitimacy of our political system. This possibility, the court apparently believes, licenses it to run roughshod over Congress's handiwork. In my view, we should instead start by acknowledging that Congress surely has both wisdom and experience in these matters that is far superior to ours. Many of our campaign finance precedents explicitly and forcefully affirm the propriety of such presumptive deference. Moreover, judicial deference is particularly warranted where, as here, we deal with a congressional judgment that has remained essentially unchanged throughout a century of careful legislative adjustment. In America, incumbent legislatures pass the laws that govern campaign finance just like all other laws. To apply a level of scrutiny that effectively bars them from regulating electioneering whenever there is the faintest whiff of self-interest is to deprive them of the ability to regulate electioneering. This is not to say that deference... I have to make sure I didn't skip anything. There is not to say that deference would be appropriate if there were a solid basis for believing that a legislative action was motivated by the desire to protect incumbents or that it will degrade the competitiveness of the electoral process. Along with our duty to balance competing constitutional concerns, we have a vital role to play in ensuring that elections remain at least minimally open, fair, and competitive. But it is the height of recklessness to dismiss Congress's years of bipartisan deliberation and its reasoned judgment on this basis, without first confirming that the statute in question was intended to be, or will function as, a restraint on electoral competition. Absent record evidence of invidious discrimination against challengers as a class, a court should generally be hesitant to invalidate legislation which, on its face, imposes even-handed restrictions. We have no record evidence from which to conclude that BCRA subsection 203 or any of the dozens of state laws that the court today calls into question reflect or fosters such invidious discrimination. Our colleagues have opined that any restriction upon a type of campaign speech that is equally available to challengers and incumbents tends to favor incumbents. This kind of airy speculation could easily be turned on its head. The electioneering prohibited by subsection 203 might well tend to favor incumbents, because incumbents have pre-existing relationships with corporations and unions, and groups that wish to procure legislative benefits may tend to support the candidate who, as a sitting officeholder, is already in a position to dispense benefits and is statistically likely to retain office. If a corporation's goal is to induce officeholders to do its bidding, the corporation would do well to cultivate stable, long-term relationships of dependency. So we do not have a solid theoretical basis for condemning subsection 203 as a front for incumbent self-protection, and it seems equally, if not more plausible, that restrictions on corporate electioneering will be self-denying. Nor do we have a good empirical case for skepticism as the court's failure to cite any empirical research attests, nor does the legislative history give reason for concern. Congress devoted years of careful study to the issue underlying BCRA. Few legislative proposals in recent years have received as much sustained public commentary or news coverage. Political scientists and academic experts with no self-interest in incumbent protection were central figures in pressing the case for BCRA, and the legislation commanded bipartisan support from the outset. Finally, it is important to remember just how incumbent-friendly congressional races were prior to BCRA's passage, as the Solicitor General aptly remarked at the time. The evidence supports overwhelmingly that incumbents were able to get reelected under the old system just fine. It would be hard to develop a scheme that could be better for incumbents. In this case, then, there is no convincing evidence that the important interests favoring expenditure limits are fronts for incumbency protection. In the meantime, a legislative judgment that enough is enough should command the greatest possible deference from judges interpreting a constitutional provision that, at best, has an indirect relationship to activity that affects the quantity of repetitive speech in the marketplace of ideas. The majority cavalierly ignores Congress's factual findings and its constitutional judgment. It acknowledges the validity of the interest in preventing corruption, but it effectively discounts the value of that interest to zero. This is quite different from conscientious policing for impermissible anti-competitive motive or effect in a sensitive First Amendment context. It is the denial of Congress's authority to regulate corporate spending on elections. Austin and corporate expenditures. Just as the majority gives short shrift to the general societal interests at stake in campaign finance regulation, it also overlooks the distinctive considerations raised by the regulation of corporate expenditures. The majority fails to appreciate that Austin's anti-distortion rationale is itself an anti-corruption rationale, tied to the special concerns raised by corporations. Understood properly, anti-distortion is simply a variant on the classic governmental interest in protecting against improper influences on office holders that debilitate the democratic process. It is manifestly not just an equalizing idea in disguise. The fact that corporations are different from human beings might seem to need no elaboration, except that the majority opinion almost completely elides it. Austin set forth some of the basic differences. Unlike natural persons, corporations have limited liability for their owners and managers, perpetual life, separation of ownership and control, and favorable treatment of the accumulation and distribution of assets that enhance their ability to attract capital and to deploy their resources in ways that maximize the return on their shareholders' investments. Unlike voters in U.S. elections, corporations may be foreign controlled. Unlike other interest groups, business corporations have effectively delegated responsibility for ensuring society's economic welfare. They inescapably structure the life of every citizen. The resources in the treasury of a business corporation, furthermore, are not an indication of popular support for the corporation's political ideas. They reflect instead the economically motivated decisions of investors and customers. The availability of these resources may make a corporation a formidable political presence, even though the power of the corporation may be no reflection of the power of its ideas. It might also be added that corporations have no consciences, no beliefs, no feelings, no thoughts, no desires. Consciences. Corporations help structure and facilitate the activities of human beings, to be sure, and their personhood often serves as a useful legal fiction, but they are not themselves members of we the people by whom and for whom our Constitution was established. These basic points help explain why corporate electioneering is not only more likely to impair compelling governmental interests, but also why restrictions on that electioneering are less likely to encroach upon First Amendment freedoms. One fundamental concern of the First Amendment is to protect the individual's interest in self-expression. Freedom of speech helps make men free to develop. Oh, this is just quoting a bunch of cases. Corporate speech, however, is derivative speech by proxy. A regulation such as BCRA subsection 203 may affect the way in which individuals disseminate certain messages through the corporate form, but it does not prevent anyone from speaking in his or her own voice. Within the realm of campaign spending generally, corporate spending is furthest from the core of political expression. It is an interesting question who is even speaking when a business corporation places an advertisement that endorses or attacks a particular candidate. Presumably, it is not the customer or employees, who typically have no say in such matters. It cannot realistically be said to be the shareholders, who tend to be far removed from the day-to-day decisions of the firm and whose political preferences may be opaque to management. Perhaps the officers or directors of the corporation have the best claim to be the ones speaking, except their fiduciary duties generally prohibit them from using corporate funds for personal ends. Some individuals associated with the corporation must make the decision to place the ad, but the idea that these individuals are thereby fostering their self-expression or cultivating their critical faculties is fanciful. It is entirely possible that the corporation's electoral message will conflict with their personal convictions. Take away the ability to use general treasury funds for some of those ads, and no one's autonomy, dignity, or political equality has been impinged upon in the least. Corporate expenditures are distinguishable from individual expenditures in this respect. I have taken the view that a legislature may place reasonable restrictions on individuals' electioneering expenditures in the service of the governmental interests explained above, and in recognition of the fact that such restrictions are not direct restraints on speech, but rather on its financing. But those restrictions concededly present a tougher case, because the primary conduct of actual flesh and blood persons is involved. Some of those individuals might feel that they need to spend large sums of money on behalf of a particular candidate to vindicate the intensity of their electoral preferences. This is obviously not the situation with business corporations, as their routine practice of giving substantial sums to both major national parties makes pellucidly clear. Corporate participation in elections, any business executive will tell you, is more transactional than ideological. In this transactional spirit, some corporations have affirmatively urged Congress to place limits on their electioneering communications. These corporations fear that office holders will shake them down for supportive ads, that they will have to spend increasing sums on elections in an ever-escalating arms race with their competitors, and that public trust in business will be eroded. A system that effectively forces corporations to use their shareholders' money both to maintain access to and to avoid retribution from elected officials may ultimately prove more harmful than beneficial to many corporations. It can impose a kind of implicit tax. In short, regulations such as subsection 203 and the statute upheld in Austin impose only a limited burden on First Amendment freedoms, not only because they target a narrow subset of expenditures and leave untouched the broader public dialogue, but also because they leave untouched the speech of natural persons. Recognizing the weakness of a speaker-based critique of Austin, the court places primary emphasis not on the corporation's right to electioneer, but rather on the listener's interest in hearing what every possible speaker may have to say. The court's central argument is that laws such as subsection 203 have deprived the electorate of information, knowledge, and opinion vital to its function. And this, in turn, interferes with the open marketplace of ideas protected by the First Amendment. There are many flaws in this argument. If the overriding concern depends on the interests of the audience, surely the public's perception of the value of corporate speech should be given an important weight. That perception today is the same as it was a century ago when Theodore Roosevelt delivered the speeches to Congress that, in time, led to the limited prohibition on corporate campaign expenditures that is overruled today. The distinctive threat of democratic integrity posed by corporate domination of politics was recognized at the inception of the Republic and has been a persistent theme in American political life ever since. It is only certain members of this court, not the listeners themselves, who have agitated for more corporate electioneering. Austin recognized that there are substantial reasons why a legislature might conclude that unregulated general treasury expenditures will give corporations unfair influence in the electoral process and distort public debate in ways that undermine rather than advance the interests of listeners. The legal structure of corporations allow them to amass and deploy financial resources on a scale few natural persons can match. The structure of a business corporation, furthermore, draws a line between the corporation's economic interest and the political preferences of the individuals associated with the corporation. The corporation must engage the electoral process with the aim to enhance the profitability of the company, no matter how persuasive the arguments for a broader or conflicting set of principles. In a state election such as the one at issue in Austin, the interests of non-resident corporations may be fundamentally adverse to the interests of local voters. Consequently, when corporations grab up the prime broadcasting slots on the eve of an election, they can flood the market with advocacy that bears little or no correlation to the ideas of natural persons or to any broader notion of the public good. The opinion of real people may be marginalized. The expenditure restrictions of 2 USC subsection 441B are thus meant to ensure that competition among actors in the political arena is truly competition among ideas. In addition to this immediate drowning out of non-corporate voices, there may be deleterious effects that follow soon thereafter. Corporate domination of electioneering can generate the impression that corporations dominate our democracy. When citizens turn on their televisions and radios before an election and hear only corporate electioneering, they may lose faith in their capacity as citizens to influence public policy. A government captured by corporate interests, they may come to believe, will be neither responsive to their needs nor willing to give their views a fair hearing. The predictable result is cynicism and disenchantment, an increased perception that large spenders call the tune, and a reduced willingness of voters to take part in democratic governance. To the extent that corporations are allowed to exert undue influence in electoral races, the speech of the eventual winners of those races may also be chilled. Politicians who fear that a certain corporation can make or break their re-election chances may be cowed into silence about that corporation. On a variety of levels, unregulated corporate electioneering might diminish the ability of citizens to hold officials accountable to the people, and disserve the goal of a public debate that is uninhibited, robust, and wide open. At the least, I stress again, a legislature is entitled to credit these concerns and to take tailored measures in response. The majority's unwillingness to distinguish between corporations and humans similarly blinds it to the possibility that corporations' war chests and their special advantages in the large realm may translate into special advantages in the market for legislation. When large numbers of citizens have a common stake in a measure that is under consideration, it may be very difficult for them to coordinate resources on behalf of their position. The corporate form, by contrast, provides a simple way to channel rents to only those who have paid their dues, as it were. If you do not own stock, you do not benefit from the larger dividends or appreciation in the stock price caused by the passage of private interest legislation. Corporations, that is, are uniquely equipped to seek laws that favor their owners, not simply because they have a lot of money, but because of their legal and organizational structure. Remove all restrictions on their electioneering, and the door may be opened to a type of rent-seeking that is far more destructive than what non-corporations are capable of. It is for the reasons such as these that our campaign finance jurisprudence has long appreciated that the differing structures and purposes of different entities may require different forms of regulation in order to protect the integrity of the electoral process. The court's facial depiction of corporate electioneering assumes away all of these complexities. Our colleagues ridicule the idea of regulating expenditures based on nothing more than a fear that corporations have a special ability to persuade, as if corporations were our society's ablest debaters and viewpoint neutral laws, such as subsection 203, were created to suppress their best arguments. In their haste to knock down yet another straw man, our colleagues simply ignored the fundamental concerns of the Austin court and the legislatures that have passed laws like subsection 203 to safeguard the integrity, competitiveness, and democratic responsiveness of the electoral process. All of the majority's theoretical arguments turn on a proposition with undeniable surface appeal, but little grounding in evidence or experience, that there is no such thing as too much speech. If individuals in our society had infinite free time to listen to and contemplate every last bit of speech uttered by anyone, anywhere, and if broadcast advertisements had no special ability to influence elections apart from the merits of their arguments to the extent they make any, and if legislatures always operated with nothing less than perfect virtue, then I suppose the majority's premise would be sound. In the real world, we have seen corporate domination of the airwaves prior to an election may decrease the average listener's exposure to relevant viewpoints, and it may diminish citizens' willingness and capacity to participate in the democratic process. None of this is to suggest that corporations can or should be denied an opportunity to participate in election campaigns or in any other public forum, much less that a work of art such as Mr. Smith Goes to Washington may be banned, or to deny that some corporate speech may contribute significantly to public debate. What it shows, however, is that Austin's concern about corporate domination of the political process reflects more than a concern to protect governmental interests outside of the First Amendment. It also reflects a concern to facilitate First Amendment values by preserving some breathing room around the electoral marketplace of ideas, the marketplace in which the actual people of this nation determine how they will govern themselves. The majority seems oblivious to the simple truth that laws such as subsection 203 do not merely pit the anti-corruption interest against the First Amendment, but also pit the competing First Amendment values against each other. There are, to be sure, serious concerns with any effort to balance the First Amendment rights of speakers against the First Amendment rights of listeners. But when the speaker in question are not real people, and when the appeal to First Amendment principles depends almost entirely on the listener's perspective, it becomes necessary to consider how listeners will actually be affected. In critiquing Austin's anti-distortion rationale and campaign finance regulation more generally, our colleagues place tremendous weight on the example of media corporations. Yet it is not at all clear that Austin would permit subsection 203 to be applied to them. The press plays a unique role not only in the text, history, and structure of the First Amendment, but also in facilitating public discourse. As the Austin court explained, media corporations differ significantly from other corporations in that their resources are devoted to the collection of information and its dissemination to the public. Our colleagues have raised some interests and difficult questions about Congress's authority to regulate electioneering by the press, and about how to define what constitutes the press. But that is not the case before us. Section 203 does not apply to media corporations, and even if it did, Citizens United is not a media corporation. There would be absolutely no reason to consider the issue of media corporations if the majority did not, first, transform Citizens United's as-applied challenge into a facial challenge, and second, invent the theory that legislatures must eschew all identity-based distinctions and treat the local nonprofits news outlets exactly the same as General Motors. This calls to mind George Berkeley's description of philosophers. We have first raised a dust and then complain we cannot see. It would be perfectly understandable if our colleagues feared that a campaign finance regulation such as subsection 203 may be counterproductive or self-interested, and therefore attended carefully to the choices the legislature has made. But the majority does not bother to consider such practical matters or even to consult a record. It simply stipulates that enlightened self-government can arise only in the absence of regulation. In light of the distinctive features of corporations identified in Austin, there is no valid basis for this assumption. The marketplace of ideas is not actually a place where items or laws are meant to be bought and sold. And when we moved from the realm of economics to the realm of corporate electioneering, there may be no reason to think the market ordering is intrinsically good at all. The court's blinkered and aphoristic approach to the First Amendment may well promote corporate power at the cost of the individual and collective self-expression the amendment was meant to serve. It will undoubtedly cripple the ability of ordinary citizens, Congress, and the states to adopt even limited measures to protect against corporate domination of the electoral process. Americans may be forgiven if they do not feel the court has advanced the cause of self-government today. 2. Shareholder protection. There is yet another way in which laws such as subsection 203 can serve First Amendment values. Interwoven with Austin's concern to protect the integrity of the electoral process is a concern to protect the rights of shareholders from a kind of coerced speech, electioneering expenditures that do not reflect their support. When corporations use general treasury funds to praise or attack a particular candidate for office, it is the shareholders, as the residual claimants, who are effectively footing the bill. Those shareholders who disagree with the corporation's electoral message may find their financial investments being used to undermine their political convictions. The PAC mechanism, by contrast, helps ensure that those who pay for an electioneering communication actually support its content and that managers do not use general treasuries to advance personal agendas. It allows corporate political participation without the temptation to use corporate funds for political influence, quite possibly at odds with the sentiments of some shareholders or members. A rule that privileges the use of PACs thus does more to facilitate the political speech of like-minded shareholders. It also curbs the rent-seeking behaviors of executives and respects the views of dissenters. Austin's acceptance of restrictions on general treasury spending simply allows people who have invested in the business corporation for purely economic reasons, the vast majority of investors, one assumes, to avoid being taken advantage of without sacrificing their economic objectives. The concern to protect dissenting shareholders and union members has a long history in campaign finance reform. It provided a central motivation for the Tillman Act of 1907 and subsequent legislation. And it has been endorsed in a long line of our cases. Indeed, we have unanimously recognized the government interest in protecting the individuals who have paid money into a corporation or union for purposes other than the support of candidates from having that money used to support political candidates to whom they may be opposed. The court dismisses the interest on the ground that abuses of shareholder money can be corrected through the procedures of corporate democracy. I fail to understand. And it seems through internet-based disclosure. Let me reread that. The court dismisses this interest on the grounds that abuses of shareholder money can be corrected through the procedures of corporate democracy, and it seems through internet-based disclosures. I fail to understand how this addresses the concern of dissenting union members who will be affected by today's ruling, and I fail to understand why the court is so confident in these mechanisms. By corporate democracy, presumably the court means the rights of shareholders to vote and to bring derivative suits for breach of fiduciary duty. In practice, however, many corporate lawyers will tell you that these rights are so limited as to be almost non-existent, given the internal authority wielded by boards and managers and the expansive protections afforded by the business judgment rule. Modern technology may help make it easier to track corporate activity, including electoral advocacy, but it is utopian to believe that it solves the problem. Most American households that own stock do so through intermediaries such as mutual funds and pension plans, which makes it more difficult both to monitor and to alter particular holdings. Studies show that a majority of individual investors make no trades at all during a given year. Moreover, if the corporation in question operates a PAC, an investor who sees the company's ads may not know whether they are being funded through the PAC or through the general treasury. If and when shareholders learn that a corporation has been spending general treasury money on objectionable electioneering, they can divest. Even assuming that they reliably learn as much, however, this situation is only partial. The solution is only partial. The injury to the shareholders' expressive rights has already occurred. They might have preferred to keep that corporation's stock in their portfolio for any number of economic reasons, and they may incur a capital gains tax or other penalty from selling their shares, changing their pension plan, or the like. The shareholder protection rationale has been criticized as under-inclusive in that corporations also spend money on lobbying and charitable contributions in ways that any particular shareholder might disapprove. But those expenditures do not implicate the selection of public officials, an area in which the interests of unwilling corporate shareholders in not being forced to subsidize that speech are at their zenith. And in any event, the question is whether shareholder protection provides a basis for regulating expenditures in the weeks before an election, not whether additional types of corporate communications might similarly be conditioned on voluntariness. Recognizing the limits of the shareholder protection rationale, the Austin court did not hold it out as an adequate and independent ground for sustaining the statute in question. Rather, the court applied it to reinforce the anti-distortion rationale in two main ways. First, the problem of dissenting shareholders shows that even if electioneering expenditures can advance the political views of some members of a corporation, they will often compromise the views of others. Second, it provides an additional reason beyond the distinctive legal attributes of the corporate form for doubting that these expenditures reflect actual public support for the political ideas espoused. The shareholder protection rationale, in other words, bolsters the conclusion that restrictions on corporate electioneering can serve both speakers' and listeners' interests, as well as the anti-corruption interest. And it supplies yet another reason why corporate expenditures merit less protection than individual expenditures. Today's decision is backwards in many senses. It elevates the majority's agenda over the litigants' submissions, facial attacks over as-applied claims, broad constitutional theories over narrow statutory grounds, individual dissenting opinions over presidential holdings, assertion over tradition, absolutism over empiricism, rhetoric over reality. Our colleagues have arrived at the conclusion that Austin must be overruled and that subsection 203 is facially unconstitutional only after mischaracterizing both the reach and rationale of those authorities, and after bypassing or ignoring rules of judicial restraint used to cabin the court's lawmaking power. Their conclusion that the societal interest in avoiding corruption and the appearance of corruption does not provide an adequate justification for regulating corporate expenditures on candidate elections relies on an incorrect description of that interest, along with a failure to acknowledge the relevance of established facts and the considered judgments of state and federal legislatures over many decades. In a democratic society, the long-standing consensus on the need to limit corporate campaign spending should outweigh the wooden application of judge-made rules. The majority's rejection of this principle elevates corporations to a level of deference which has not been seen at least since the days when substantive due process was regularly used to invalidate regulatory legislation thought to unfairly infringe upon established economic interests. At bottom, the court's opinion is thus a rejection of the common sense of the American people who have recognized the need to prevent corporations from undermining self-government since the founding, and who have fought against the distinctive corrupting potential of corporate electioneering since the days of Theodore Roosevelt. It is a strange time to repudiate that common sense. While American democracy is imperfect, few outside the majority of this court would have thought its flaws included a dearth of corporate money in politics. I would affirm the judgment of the district court. Justice Thomas concurring in part and dissenting in part. I join all but Part 4 of the court's opinion. Political speech is entitled to robust protection under the First Amendment. Section 203 of the Bipartisan Campaign Reform Act of 2002, the BCRA, has never been reconcilable with that protection. By striking down subsection 203, the court takes an important first step toward restoring full constitutional protection to speech that is indispensable to the effective and intelligent use of the processes of popular government. I dissent from Part 4 of the court's opinion, however, because the court's constitutional analysis does not go far enough. The disclosure, disclaimer, and reporting requirements in BCRA subsections 201 and 311 are also unconstitutional. And see note 10. Congress may not abridge the right of anonymous speech based on the simple interest in providing voters with additional relevant information. In continuing to hold otherwise, the court misapprehends the import of recent events that some amici describe, in which donors to certain causes were blacklisted, threatened, or otherwise targeted for retaliation. The court properly recognizes these events as cause for concern, but fails to acknowledge their constitutional significance. In my view, amici's submissions show why the court's insistence on upholding subsections 201 and 311 will ultimately prove as misguided and ill-fated as was its prior approval of subsection 203. Amici's examples relate principally to Proposition 8, a state ballot proposition that California voters narrowly passed in the 2008 general election. Proposition 8 amended California's constitution to provide that only marriage between a man and a woman is valid or recognized in California. Any donor who gave more than $100 to any committee supporting or opposing Proposition 8 was required to disclose his full name, street address, occupation, employer's name, or business name if self-employed, and the total amount of his contributions. The California Secretary of State was then required to post this information on the internet. Some opponents of Proposition 8 compiled this information and created websites with maps showing the locations of homes or businesses of Proposition 8 supporters. Many supporters or their customers suffered property damage or threats of physical violence or death as a result. They cited these incidents in a complaint they filed after the 2008 election, seeking to invalidate California's mandatory disclosure laws. Supporters recounted being told, "Consider yourself lucky. If I had a gun, I would have gunned you down along with each and every other supporter, or we have plans for you and your friends." Proposition 8 opponents also allegedly harassed the measure's supporters by defacing or damaging their property. Two religious organizations supporting Proposition 8 reportedly received through the mail envelopes containing a white powdery substance. Those accounts are consistent with media reports describing Proposition 8 related retaliation. The director of the nonprofit California Musical Theater gave $1,000 to support the initiative. He was forced to resign after artists complained to his employer. The director of the Los Angeles Film Festival was forced to resign after giving $1,500 because opponents threatened to boycott and picket the next festival. And a woman who had managed her popular family-owned restaurant for 26 years was forced to resign after she gave $100 because throngs of angry protesters repeatedly arrived at the restaurant and shouted "Shame on you" at customers. The police even had to arrive in riot gear one night to quell the angry mob at the restaurant. Some supporters of Proposition 8 engaged in similar tactics. One real estate businessman in San Diego who had donated to the group opposing Proposition 8 received a letter from Prop 8 Executive Committee threatening to publish his company's name if he didn't also donate to the Yes on 8 campaign. The success of such intimidation tactics has apparently spawned a cottage industry that uses forcibly disclosed donor information to preempt citizens' exercise of their First Amendment rights. Before the 2008 presidential election, a newly formed nonprofit group planned to confront donors to conservative groups, hoping to create a chilling effect that will dry up contributions. Its leaders, who describe his effort as going for the jugular, detailed the group's plan to send a warning letter alerting donors who might be considering giving to right-wing groups to a variety of potential dangers, including legal trouble, public exposure, and the watchdog groups digging through their lives. These instances of retaliation sufficiently demonstrate why this court should invalidate mandatory disclosure and reporting requirements. But amici present evidence of yet another reason to do so: the threat of retaliation from elected officials. As amici's submission makes clear, this threat extends far beyond a single ballot proposition in California. For example, a candidate challenging an incumbent state attorney general reported that some members of the state's business community feared donating to his campaign because they did not want to cross the incumbent. In his words, "I go to so many people and hear the same thing. I sure hope you beat the incumbent, but I can't afford to have my name on your records. He might come after me next." The incumbent won re-election in 2008. My point is not to express any views on the merits of the political controversies I describe. Rather, it is to demonstrate, using real-world recent examples, the fallacy in the court's conclusion that disclaimer and disclosure requirements impose no ceiling on campaign-related activities and do not prevent anyone from speaking. Of course they do. Disclaimer and disclosure requirements enable private citizens and elected officials to implement political strategies specifically calculated to curtail campaign-related activity and prevent the lawful, peaceful exercise of First Amendment rights. The court nevertheless insists that as-applied challenges to disclose requirements will suffice to vindicate those speech rights, as long as potential plaintiffs can show a reasonable probability that disclosure will subject them to threats, harassment, or reprisals from either government officials or private parties. But the court's opinion itself proves the irony in this compromise. In correctly explaining why it must address the facial constitutionality of subsection 203, the court recognizes that the First Amendment does not permit laws that force speakers to seek declaratory rulings before discussing the most salient political issues of our day. That as-applied challenges to subsection 203 would require substantial litigation over an extended time and result in an interpretive process that itself would create an inevitable, pervasive, and serious risk of chilling protected speech pending the drawing of fine distinctions that, in the end, would themselves be questionable. That a court would be remiss in performing its duties were it to accept an unsound principle merely to avoid the necessity of making a broader ruling, and that avoids a facial challenge to subsection 203 would prolong the substantial nationwide chilling effect that subsection 203 causes. The logic, of course, applies equally to as-applied challenges to subsection 201 and 311. Irony aside, the court's promise that as-applied challenges will adequately protect speech is a hollow assurance. Now more than ever, subsections 201 and 311 will chill protected speech because, as California voters can attest, the advent of the internet enables prompt disclosure of expenditures, which provide political opponents with the information needed to intimidate and retaliate against their foes. Thus, disclosure permits citizens to react to the speech of their political opponents in a proper or undeniably improper way long before a plaintiff could prevail on an as-applied challenge. I cannot endorse a view of the First Amendment that subjects citizens of this nation to death threats, ruined careers, damaged or defaced property, or preemptive and threatening warning letters as the price for engaging in core political speech, the primary object of the First Amendment protection. I'll make sure I don't skip anything. I respectfully dissent from the court's judgment upholding BCRA subsections 201 and 311. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop in the comments and we'd be happy to take a look. Thank you.